Hi, good afternoon everyone. This is Rajiv S. Khanna from immigration.com, the law offices of Rajiv S. Khanna PC. Today is February 22nd and this is our bi-weekly conference call. We have a community conference call every other Thursday. I have not had a chance to review the questions today, so I'm just going to go through the questions one by one. I didn't have a chance to mark them as frequently asked questions. So I'll just go through them. The first one actually, Srini 20, I was just looking at it, seems to be a frequently asked question. The essence of the question is, from Srini 20, the essence of the question is, I am on H1, how do I convert to EAD? I've got an EAD. I want to go from having an H1 to working on an EAD. Well, that's a good question. There really is no formal procedure necessary. The way it works is when any employee joins any employer in the United States, the employer is supposed to fill for them a form I-9. It's an employment verification form. Basically, review your right to work in the United States and fill the form I-9. I-9 doesn't get submitted to the government. Government can check into it, they can do audits, but I-9 remains in the employer's files. So all you have to do is, if you want to convert from H1 to EAD, you just walk over to your HR and say, could you please update my I-9 with my employment authorization? And if you currently are on H1, you should have your employer send in a request to revoke your H1 because the employee, that is you, is moving to employment authorization document, EAD. Okay. So really all you have to do is walk it over to your HR and tell them to update your I-9 to reflect that you're no longer working on H1, instead that you are working on EAD. So let's look at the question real quickly. Applied for, I continue by employment with the same H1B employer. 240 days are expiring. When I-485 and EAD is filed after H1B I-94 expired and pending H1B extension. Now here's another issue here. I don't know if this is an issue in your case. You applied for 7th year H1B extension in May 2017. 1 month after the start of my period of authorized stay, pending H1B extension and expired I-94, applied for I-485. Oh, okay. That's important. So there's another interesting issue here, which is section 245K as in kite. You probably all know about it already. But section 245K says, if you're an employment-based applicant, we will allow you to be out of status for up to 180 days or even to work without authorization for up to 180 days. So in this gentleman's case, Srini's case, his H1 expired, but a timely filed extension was pending, and within a month of the expiration, they filed I-485. Now remember, even if he had filed 179th day, he would be okay. So there's no problem here. The EAD is good. The I-485 is good. Let's see, when I-485, does it matter now if my H1B job extension is denied? No, it does not matter anymore, because within 30 or 40 days, less than 180 days of your I-94 expiring, you had filed I-485 and you've got an EAD. And the last question was what I discussed first. How do I shift from H1B to EAD? And the answer is no special magic. Just walk over your EAD to your HR, tell them to update your form I-9. Any follow-up questions on this, press *9. No new questions? Any follow-up questions on this, *9. Ravi Thalapaneni says, when I was with my primary employer, I got another job offer with employer B, applied for H1B transfer, and after working for B for almost 6 months, transfer was denied with level 1 wage RFE. I went back to employer A and he filed H1B amendment and it is still pending. Now I've got another job offer with employer C. If I did again transfer my H-1B to employer C, is there any chance to get H-1B approval without I-94? Yes. Yes. The way this works, Ravi, is that let's forget employer B because you stopped working for them and you went back to employer A. If you file through employer C while your application through employer A excuse me, is still pending, then on the date your subsequent application is decided, which is through employer C, if the old application is still pending, they won't give you status within the United States. So if it is still pending or denied, you won't get status within USA. You will get your H-1 approval without I-94. The only time you get an H-1 approval with an I-94 in these cases is if when the employer C's application comes up for adjudication, employer A's amendment is already approved. That's the only time you will get status within the United States. *5 if you have a follow-up question. Okay. We go on to Monarch's question. Planning to apply for reentry permit for my father for 2 years. What are my options to not break the continuous presence? Look, first of all, in order for somebody to have continued presence in the United States, they have to make USA their permanent home. This is not complicated. This is an easy question and an easy answer. Do you live in the US? Yes or no? If you live in USA, then you need to worry about continuous presence for naturalization. If you're not even living in USA and you're just visiting periodically, you probably will not be able to form the necessary continuity. Sometimes they can go after a green card. People have gone in for their naturalization and ended up getting their green card attacked. That can happen. Can we apply for a re-entry permit again after 2 years? Sure, you can. What are your recommendations? Well, first of all, if you want him to apply for naturalization, he's got to move to the United States. He can go visit India every few months. 3-4 months a year is okay. But you cannot expect to maintain your green card or citizenship continuity if you're only visiting USA and living in India. My recommendation would be to move here. As far as re-entry permit is concerned, first couple of years they're pretty easygoing if you have a good reason. For instance, many times people have property to settle or other personal necessity. I've known people where there are students who are studying outside USA. Those are the kind of cases where they are quite easygoing about giving you a re-entry permit. Second extension for another 2 years is usually not that difficult if the need to be outside USA remains temporary and continues. I never recommend anybody file their own re-entry permit. There are some legal issues here. I can name one of them. For example, if you leave the United States, either with the intention, so let me take a step back. You've got your green card. If you leave the United States not knowing when you will come back, or with the intention never to come back, even if you come back 10 days later, government can make the case, arguably, that you've lost your green card because you departed either not knowing when you are coming back or with the intention not to come back. So, therefore, be careful with these issues. There are some legal technical issues. Get yourself a lawyer. Don't do it yourself. Even though it looks like just one-page form, it isn't something I would recommend that people do themselves. Re-entry permits should be done with the advice of competent counsel. *5 if you have a follow-up question on this. Press *5. Okay. Let's go on to the next question. This is Anup C. I'm planning to renew my 10-year employment-based green card. I enter through consular processing. In I-90, there's a question. First of all, we cannot help you fill forms, because if we help you fill forms, then we have to sign the forms. It's just unethical for me to answer questions that specific. But generally speaking, you are concerned I don't remember where you entered. Is there any way to find out what I said or filled? Yes, you can always get a copy of your paperwork, which the government has, by filing a Freedom of Information Act request, both with USCIS and Customs and Border Protection. You should be able to get a lot of your documents, pretty much everything that they have on you. And by the way, if you file something and you're not sure of the facts, I have had cases where people traveled to Canada 50 times during 5 years. They don't remember when they went and when they came back because Canadian visits are not tracked. I have always told people, just make a good faith estimate and attach a cover letter saying I'm making a good faith estimate. I don't remember where I entered or how many times I've been in and out. So that's usually okay. I don't see that Form I-90 incorrectly filed with your last destination, entry destination, would be a difficult issue to overcome. So you could probably do it without waiting for a Freedom of Information Act request. But FOIA is easy to do. It doesn't cost you any money. You could do it. Star 5, if there's a follow-up question on this, star 5. Chandra 25 his mother has applied for, or her mother has applied for a green card, applied for a re-entry permit, wants to go back. What happens to the re-entry permit if she decides to come back to USA before the 2-year limit? Does that invalidate the 2-year re-entry permit and she has to apply again? No, sir or ma'am. The way it works is a re-entry permit is a multiple entry document for most countries. So when you apply for a re-entry permit for 2 years, that means you can come and go as many times during those 2 years as you like without negatively impacting your approval. You have the option but not the obligation to come as many times as you like. So it's not that you have to keep coming back, or if you come back you would lose the rest of the approved period. That's not a problem. Okay, star 5 if you have a follow-up question. Yeah, so a re-entry permit is like a multiple entry visa. You can use it multiple times during the time that it's valid. Vilas 80 says, my current employer A is in the process of filing an H-1B amendment as I am moving to a new location. Also, I got another offer from B who will file for an H-1B transfer. Can I have both an H-1B amendment and transfer at the same time? Yes, you can. I really want to join employer B, and does H-1B amendment from employer A affect my H-1B transfer with employee B? No, it does not. What I would recommend is, as long as you get the transfer filed before you move, and your I-94 and your permission to work is still valid, whatever happens with employer A's application should be irrelevant, as long as you have filed employer B's application within the life and within the geographical location of the currently approved H-1. See, there's a difference between filing a transfer after you move and file amendment and before you move. Okay, so you should be able to do this without any problem. Star 5 if you have a follow-up question. Okay, let's go on to the next question. Satish 1601 says, is there a time limit on the number of volunteer hours an H-1B can volunteer for a non-profit organization, a temple? Oh no, sir. You can spend as much time as you like. Can a legal non-immigrant be part of the board and hold a position at a non-profit? Definitely. As long as you don't get paid for it in cash or in kind, that is fine. There's no problem. So when you work for something like a temple, and volunteering is common for these kinds of situations, I don't see any problem at all, whether you are an H-1B, L-1B, F-1, H-4, L-2, any visa. Srinivas Vadadi says, my first master degree is not STEM as my school lost its accreditation during my final semester. I graduated with 12 months OPT thinking my H1 would be picked. It did not. I joined second masters and filed H1B again. It did not pick. My second master is also ending soon. What are my options to say? I have a valid F1 visa till August 2019. The visa itself is not significant. I'm willing to go on to PhD if that is an option. Sure, PhD is an option, but remember that at some point, if your intention is just to keep extending your stay, it can certainly be problematic either at the airport when you're coming in or if you ever go for a visa extension or restamping. So therefore, theoretically, it is possible to join PhD or even a third master's. I won't recommend that. PhD certainly seems to be a better option, but you must be genuinely interested in the course. Otherwise, excuse me, the government can question your good faith, whether you're just trying to extend your stay or are you really an honest student. *5 if you have a follow-up question. B. Sundar, my wife is currently on H4 visa with EAD. Employer plans to file for H1 in April. Can we go for H4 visa stamping while employer has filed for H1 visa? No. That will be problematic because when you have a change of status request pending from H4 to H1 along with the H1, traveling outside would abandon that change of status request, which means when you come back after your H4 visa, although come to think of it, yeah, the change of status request is deemed to be abandoned. I'm a little confused about this, I must confess, because H1 is proactively going to kick in only in October. Whether you travel outside or not shouldn't matter. But as far as I recall, there is a comment from the government that if you travel during a change of status request, we consider the request deemed to have been abandoned. Although, when you do it from F1 to H1, you can travel in most circumstances. I must confess, I'm sorry, I didn't get a chance to review these questions today beforehand. So some of these issues I don't remember off the top of my head. I would certainly want your lawyers to look into travel on H4 while the H1 is pending. My guess is that the H1 is deemed, the change of status is deemed to be abandoned, which means when she comes back and if the H1 gets approved, she'll have to go outside USA for visa stamping for H1 or refile change of status from H4 to H1, which is like doing the H1 all over again. So it becomes definitely more troublesome. Okay. *5 if you have a follow-up question. Ali Zain says, this one is a little complicated because this goes back a few years. I want to talk about it anyway. I first entered USA around 1997, uninspected, which means coming through a border without having, kind of sneaking in. Applied for labor cert in Feb 2001 and got the 245I benefit. But the employer did not show me any confirmation or anything. Then I went back to India in 2004. After 10 years, which means you should be okay, I got a visitor visa and came to USA. Now if I apply for my labor cert and I-140 with new employer, benefit under 245I, unauthorized presence waiver currently and before, retaining the old priority date. Well, I can answer some of these questions. 245I benefits won't, as far as I know, don't protect you from the second visit. Second time you have overstayed and become unlawfully present, subject to 10-year bar, you've got the same problem. Unauthorized, excuse me, I've got a little bit of allergies. Unauthorized presence waiver, current and before. I don't think you need an unauthorized or unlawful presence waiver from before, because in that case you were already gone for 10 years. So that's old. I don't think you will need one for that. And for unauthorized presence waiver for now, or unlawful presence waiver for now, that would be quite difficult. It is only given under limited circumstances, and you need to examine it only if you are married to either a US citizen green card holder, or your child is a US citizen or green card holder, and they would suffer extraordinary hardship, extreme and exceptional hardship. That's the phrase they use. Only then you can get a waiver of the unlawful presence bar. *5 if you have a follow-up question. *5. Okay. Imikumar 2017, I work for an in-house project for company A. Company got acquired by company B. Do I need to do my current H-1B amendment? I said, he asked me this question before, and I said if the company B became a successor in interest, you don't have to do an H-1B amendment. What do you mean by successor of interest? It is not successor of interest, it is successor in interest. And this is a legal determination. I can't teach you law. You have to let your lawyers tell you, because it depends also not only on immigration law, but on corporate law, what kind of takeover or acquisition occurred. So it's a mixed question of both corporate and immigration law. Is there going to be any issue in visa stamping? Look, if the successor in interest situation exists, it is no more difficult than an ordinary H-1. And they are difficult by themselves. So yeah, H-1s can be always problematic. But you're working in-house, that usually makes things simpler. Successor in interest, if it is properly set up by itself, should not delay your visa stamping. This is really what the questions you're asking me should be addressed to the corporate lawyers. What document should I ask? There's usually a letter that explains the transaction to the government and kind of lays it out for them how this is a successor in interest case. In case an RFE is raised, how long will it take? And you mean if at the consulate level, it can take a long time, months upon months, and it could end up in the consulate sending the case back to the USCIS for revocation. That happens too. I have I-140 approved, priority date is March 2011. Yeah, you need to file the I-140 again. It's called I-140 amendment, but basically you are redoing the I-140 if there is a successor in interest. I don't think you have a choice in that. *5 if you have a follow-up question. Okay. Laila Greedo says, I need to clarify some information regarding my son's green card. So he's 6 years old. He got his green card through his mother, which is Laila, in April 2017. Became a permanent resident. Got my green card. I live and work in Florida. Once we got our green card, he was living in Brazil and finishing his school. So he came from time to time. Now I'm planning on bringing him here for good, but he's still finishing his school year. I think this is not going to be a major issue, Laila, because he just got his green card in April of 2017, and from then to now he's come and gone a number of times. If he's finishing his school, just make sure he doesn't stay outside the United States for 6 months at one go, and as long as he's coming back soon to live here permanently, I do not anticipate this being a major problem. Okay, so keep bringing him back within 6 months each time, and then you're going to move him anyway. So he was here July, August, then December, January. I think you'll be fine. I'm not worried about it because he had a good reason to stay outside. He was finishing his school year. Just bring some evidence of that, like some letter from school, some attendance record, whatever the school can give you, and that should fix the problem. *5 if you have a follow-up question. I have one follow-up question hand raised. If you press *5 again, your hand goes down. So please, yeah, okay. All right. So let's deal with that question from Pennsylvania. Yeah, Pennsylvania, go ahead, please.
Hi, Rajiv. Good afternoon.
Good afternoon, sir.
This question is previous one. Successor of interest.
Right. Right. Go ahead.
Actually, the company has been acquired is, I don't know exactly whether it's successor of interest, but looks like that is a big company, and then they are going to take some of the modules, and they also bought some of the modules, and it's going to be like under one roof from now. So,
well, I can't give you a definitive decision whether this is a successorship issue or not, because that's something your corporate lawyer and or immigration lawyers have to decide after they review the transaction. In order for successor in interest to be implemented, you don't have to take over the whole company. Sometimes you can take over even a part of the company as long as the account books are maintained separately. So it isn't something I can really help you with without knowing what the transaction is.
Okay, so I need to go and talk to my HR and,
yes.
And then they need to contact the immigration lawyer as well as the corporate lawyer.
Right. I'll tell you this. I would be shocked if they have not planned for this, because I personally don't know any even small to medium-sized takeover or merger or acquisition or any kind of a corporate ownership transfer where immigration law was not considered. They always consider those situations. So I'm pretty sure they would have planned for it. Talk to your HR.
Okay, actually before this acquisition I bought the air ticket to go to India in June, but now I am kind of hesitating because I need to get a visa as well, but I didn't get reserve my consulate appointment, so I'm just waiting for it. So
yeah,
looks like I need to get all cleared.
I think you should speak with your HR before you plan anything. Okay?
Okay, Rajiv. All right. Thank you very much.
You're welcome. Good luck, sir. Okay, so skipping the next question, we already dealt with this. Sunny 247. We are in a unique situation while extending our H-1B, and our I-94 is expired now. We've applied for extension of H-1B after 6 years. 6 years were not completely used, plus H-4 plus H-4 EAD in premium processing. We have an approved I-140 for more than 180 days. We paid for H-1B premium and H-4 EAD. Employer paid for H-1B and H-4, but we did a mistake by sending 2 checks. So a case is not considered to have been filed until it has the right filing fees. So what that would mean is you would be out of status if there's a gap between your first filing and the second filing. The first filing will get rejected and you would have to refile the case with appropriate checks. Our I-94 expired Jan 31st. Documents reached US here Jan 16th. I don't think your lawyer has covered the whole picture. See, what happens is on January 31st, your I-94 expired. So you have 180 days to leave the United States. Otherwise, you'll have a 3-year bar. But that doesn't mean that you are legal. If you are caught, you can be deported. because you are illegal in the United States. But if you have some efforts going on towards trying to correct this situation, I doubt very much the government is going to deport you. Nevertheless, you need to be aware of the 180-day deadline. If your status is not resolved by June, count 180 days from January 31st, you have to leave the USA and go outside and wait for your status issues to be resolved. Yeah, you can just refile the case, explain the situation with the proper fees, of course, and ask the government to give you status because this was all a big snafu. I don't think they will, but you never know. You can try, but be prepared to leave. Don't stay beyond 180 days. Leave before 180 days. *5 if you have a follow-up question. Okay, there's a follow-up question. Just a second. This is from Minnesota. Minnesota, go ahead, please. Minnesota.
Hello, Rajiv ji. I'm Sunny 247.
Yes, ma'am.
The question is, actually, our attorney refiled the case again, and we are sure that the package received USCIS now.
Okay.
And we are waiting for the second filing receipt numbers.
Okay.
The question I have is, I'm 24 weeks pregnant now.
Okay.
And we lost a baby last summer, so with a high-risk pregnancy, the doctor is suggesting not to travel outside the country now.
See,
so all the
here is what you should do. Here's what you should do. What will happen is, first of all, keep an eye towards June. Will you be able to travel in June?
My due is around May-mid, actually.
So you'll be able to travel in June if required, right? Towards June. Towards June end.
June? I think so.
Yeah, because I don't know what's going to happen with your case. Keep the June deadline in mind. That's 180 days from January 31st. And what you do is, government is going to send you a bounce back, an RFE saying, how have you maintained status? You go ahead and explain to them that you gave the paperwork to the employer and to the lawyers. These were circumstances beyond your control. And also attach the fact that you cannot travel because of your high-risk pregnancy. Attach a letter from the doctor. You might be able to get status within the United States. May not have to travel.
Okay.
Okay.
Okay, thank you so much. Because while refiling, all the doctor certificates and all the reports have been submitted stating that this is high-risk pregnancy.
Good. So the thing is, right now you don't need to worry about anything but focus on the baby. You are okay till June. I don't think anybody's going to try to deport you. That would be horrible. I don't think that's ever going to happen. Sit tight. Do your, go through your pregnancy, rest up. In June, if it is not resolved, you can always plan to travel and you'll be fine.
Okay. And one more question, like, is there a way that we can contact a local senator or local congressman to approach this case? Because I'm so nervous now, like, because this is again a premium processing that we did.
Sure.
Refile it off.
Sure. You can. It can happen. It can happen that incorrect fees was submitted or some check got dropped off. This can happen to anybody. Really, the ultimate result of this is either you get status within the USA or you have to travel outside USA for a visa stamping within 180 days. So we'll see how it goes. I wouldn't be surprised if they approve your status within the United States. There is some healthy chance. You can approve a senator or a congressman once you get a receipt. It doesn't hurt. You can ask them to put in a good word. I don't think it will hurt. I'm not sure the pros and cons. I haven't thought about it long enough. Maybe your lawyers can advise you on that, but legally speaking, there's nothing stopping you from doing that.
Okay. Thank you so much, Rajiv.
You're welcome. Yeah, good luck. Don't worry too much about this. This is not something you need to be concerned about. You'll be all right.
Thank you so much.
Bye.
Bye.
Okay, let's go on to the next one. Wait. Okay, we did this one. Oh, Sunny has another one. Oh, she's already covered that. Okay, so we don't need to revisit that. Now we come to Shubh Chintak. I hold H-1B and the visa stamp, but I've been working for my employer while I'm outside the USA for last 1 year. If I enter USA on L2, can I work for the same employer using L2 EAD? Oh, absolutely. Absolutely. Because L2 EAD will allow you to work, no problem. What will happen to my underlying H-1B status? You can switch back to H-1B by simply going outside USA and coming with H-1B stamp. Exactly. So, or you can apply for change of status within USA from L2 to H-1B. You can do either one of those things. *5 if you have a follow-up question. *5. Okay. Let's go to Anisur Rahman. If I change my employer while my I-140 is approved and I-485 is pending for more than 180 days under EB2, will my new employer need to file PERM, I-140 and 485? Oh no. Only thing you will need to file is a supplement J. J as in John. If it takes about 6 to 9 months to get approved I-485 for the applicants of my country, however, the new employer, how long will I have to wait? I don't think this is going to cause you too much additional wait, except that if they schedule you for an interview, that's very difficult to say how it's going to play out. But if you have a good job offer, I don't see why you shouldn't take it. Just make sure that the new employer is willing to sign on the form supplement J. Okay. *5 if you have a follow-up question. *5. Okay. Victor _GA. I have an H-1B with employer A working for employer B. Client to employer A and currently valid till March 2018. Got my I-140 approved on Jan 2018. Employer A is applying. Okay, I'm lost here. H-1B with employer A, working for employer B, client to employer A. Oh, I see what you're saying. So you have a client who you're calling employer B. Employer A is applying H-1 extension. Employer B would like to sponsor my H-1. Do I need to stay employer A for 180 days to make use of the priority date in I-140? Well, the way this works is, the moment your I-140 is approved, the priority date is yours. But if you can stay another 180 days after the approval and you don't have to stay, just the I-140 is not revoked for 180 days, you also then have a permanent right to keep extending your H-1 with any employer based upon the old I-140. Now remember, the new employer will have to file a green card again, but your right to your priority date becomes solid the moment the I-140 is approved. There's no 180-day deadline on that. But if the case stays approved for 180 days, you also crystallize your right to keep extending H-1 with any employer. Okay. *5 if you have a follow-up question. Okay, let's go on to the next one. Oh, there it is. There's a follow-up question. Let's see. This one is from Illinois. Yes, Illinois, go ahead, please. You have a follow-up question?
Hi, Rajiv.
Yes, sir. Go ahead.
This is like the current H1. I have another 2.5 years, 2.5 years on my current H1, which is being applied for extension.
So I don't see any particular
How
advantage.
fast the new employer has to
Yeah, I don't see any particular advantage in staying then, because if you have enough time on your H1 and you have to redo the green card anyway, so you can leave.
Okay, thank you.
Good luck. Okay, let's go on to Jordan 31884 says he consulted me in 2015 for notice of intent to deny. That worked out, I guess. Good. I have my I-140 approved for more than 180 days with the current employer. I want to change jobs for better opportunity. Is it advisable to change jobs in current political scenario? Why not? I mean, these laws are pretty laid out. Trump can try to hurt immigrants as much as he's trying to, but he still cannot go beyond laws. As you have seen, DACA action and his Muslim ban has been severely restricted by courts. So he can't go beyond a certain limit. I would still want your lawyers to assess the move, but I am not stopping anything just because the environment is tough. As long as it is legal, I don't see any problem doing it. My I-140 is approved and going to finish my 6th year in 2019. If I change my current employer, when it's required to start a new I-140, there's no time limit on that. Anytime they want. If they refuse to start I-140, by the way, it's not the I-140. They have to start from PERM. They have to start all over from the very beginning. You still carry your priority date, but they have to start from the very beginning. You can also, if they refuse to do it, you can, I guess the only thing you can do is change employer to somebody who's willing to file your green card again. If the new employer fires me, what are my options to stay in the US? Well, I don't think you would have too many options without an H1 because your current right to stay in the US is governed by your H1. Can I file extension for my wife's H4EAD based on the current I-140? You can. And if your I-140 stays, that's another advantage of keeping it approved for 180 days. You can, if you're, let's see, was your I-140 approved for 180 days? Oh yeah, it is approved. Yeah, the USCIS has said they will let the benefit of the H1 extensions also go into the H4EAD extensions. So you don't have to wait for the second I-140 or second H1. You can keep extending her H4 based upon the existing I-140. I don't see that as a problem. Is it advisable not to go with consulting companies? That depends. We've gotten 4 approvals in just the last week on consulting companies. It depends upon, I mean, I'm talking about one particular company I remember because I talked with them yesterday. I think we are getting approvals still, but you need to be able to document what the government wants to see. Specifically, they want to see a letter from the end client verifying certain things. But it's easier if you have in-house work. Yeah, I think, Jordan, I've covered your issues. Star 5 if you have a follow-up question. Star 5. Okay, I have about 15 minutes. Any questions at all, guys? Star 5. Anyone has any questions? Star 5. Okay, 1, 2. All right. So we have 2 calls. One is, I don't know, it's a voice over IP, and the other one is Wisconsin. So let's start with the voice over IP. Go ahead with your question, please.
Hi, Rajiv.
Hello.
Hi.
Yes,
You hear me?
I can hear you. Yes, please go ahead.
Okay, thank you. Actually, I have just a quick question. I'm Canadian citizen. I am in the NAFTA list, like I finished in computer science, network technology, over 10 years experience. I have been trying applying for many companies, like, online, but nothing so far. I haven't get anything, any offer.
Okay.
Do you have any advice? I know that many Canadians, they get, especially on W2, TN visa, right? TN visa, I guess.
Right.
Do you have any advice for me? Do you have any connection with the recruitment?
No,
I would really appreciate.
That's unethical for us to get involved with the recruitment part, because if we are the lawyers and we are also the recruitment agency or recruitment helpers, that's unethical. So I personally think that your biggest selling point is that you don't need an H1. You can get a TN. So you should make it clear to your potential employers, eligible for TN, which can be obtained overnight. So you can just put in your resume, eligible for TN visa, which can be obtained overnight.
Okay. Just my question is, I know that you are not involved. Do you have any advice, any website or anything that I can get into? I know that I am eligible from your information I got, but I don't know how to get into.
That's what I said. That if you put it in your resume or cover letter, they will know that they don't have to wait 6 months for you to get an H1, and they don't have to go through that process. A TN is relatively much easier visa to get. So just make it a part of your cover letter and or your resume that I'm eligible for TN, which can be obtained overnight.
Okay. Any particular website that you advise?
No, that's something that only other job seekers can help you with. I have never looked for a job in technology, so I really don't know what is good. I wish I could help you more, but I don't have any recommendations on that. By the way, is that Quebec I hear in your voice?
Sorry?
Is that Quebec I hear from your voice? Are you from Quebec?
From Toronto.
From Toronto.
No, it's from Toronto.
Oh, okay.
From Toronto, Canada.
Yeah. Okay. So
okay. Thank you. Thank you so
no
much.
worries at all. Good luck to you, ma'am.
Thanks. Bye-bye.
Bye. Okay. So let's see. We've got one more question, and that one was from Wisconsin, I think. Okay. Yeah, that's Wisconsin. All right, Wisconsin, go ahead, please. This is the last question of the day.
Hello?
Yes, sir.
Hello, Rajiv. Can you hear me?
I can hear you just fine.
Yeah. Okay, I had a quick question. So, I had filed for, so my visa, my first 3-year H1 was done. So my company had applied for H1 extension. So I have that approved until February 2019. So my question is, because I have to travel to India next month, I just wanted to know if I go for visa stamping, I need to have 1 year of left on my extension, or is it fine, like I can go for the stamping?
There is no such requirement of law that you've got to have H1 valid for a year. By the way, are you entitled to extension? Are you entitled to an H1 extension?
Yeah. There will be another extension. I have to file for another extension. I will have another 1.5 years after that.
Hang on. When is your current H1 expiring?
Yeah.
You said, when is it expiring?
So my first 3-year H1 expired in August 2017. So I had filed, but like since my passport was expiring, so my company filed an extension before that, and that extension was until February 2019.
Okay. So that means,
so after that I'll have another extension. I can file after that.
Right. That means you can file for an extension 6 months ahead of February. So
yeah.
Okay. All right. Yeah, I don't see any problem with trying to get a visa stamping on duration less than 1 year. especially if the company makes it clear
Okay.
that they intend to apply for an extension for you.
Okay, I see. Okay, yeah, that's all I had. Yeah.
Well, good luck, sir.
Thank you.
All right, bye-bye. All right, folks, as always, it is a pleasure and a delight and a privilege to talk with you every 2 weeks. We'll talk again in a couple of weeks. Until then, bye-bye. Every other Thursday at 12:30 p.m. Eastern Standard Time, we host free community conference calls. Everybody is welcome to join. Some people post questions ahead of time. You can take membership in our forums. All of the details are there on our website, immigration.com. You can take membership ahead of time, and it's instantaneous. It happens right away. And post your questions beforehand, or you can just log in. The phone number and all are provided: 202-800-8394, 12:30 Eastern Standard Time every other Thursday. We have free apps for both Apple iOS platform for your iPhones and iPads, as well as for Android. Just look for immigration.com, the period dot, and the application should show up.